Goal 5 Cultural Areas Rulemaking Advisory Committee. This voice is of Kirsten Green, the Deputy Director, and the serve as the tribal liaison at the Director's Delegation. And really pleased to have a great turnout today. I'd love to appreciate everyone making time. Would like to turn over to Commissioner Thompson for any kind of welcome you'd like to give, Commissioner.
Oh my goodness, we are at the conclusion of a significant stage. I'm grateful to all our partners. I just love that we are creating a unified and respectful culture among all Oregonians. Thank you.
Thank you, ma'am. And we get better all the time for sure. We have a long way to go, as you've noted in the past. So we do have a meeting agenda. I know, Amanda, you were editing it. Would you like to bring it up or should I bring it up locally here?
It is saved as agenda 2. Actually, I have it right here. So open it up and I will share my screen.
Thank you, because I
Good
don't think I
morning,
see
or
agenda
we're
2.
still morning. Yes, good morning, everyone. Hope you are all doing well. Going here and I'm sharing my screen.
And for the record, I don't think I see agenda 2 in the folder, so you may have it locally. Then no matter if you're willing to share it.
Well, no, okay. I'm not sure why it's not showing up, and I'm just sharing one document, so that's share.
Thank you. Could we actually hear from everybody today? This has been such a group effort. I wonder if we could just do intros. This is, without getting too emotional, we're very grateful for everyone's participation so far, and we absolutely would not be here without each participant on. So before we dive into specific aspects, oh, and Elliot, if you wouldn't mind bringing over Counselor Anderson, Ms. Jess Miller, and RAC member Keenan, and I think LOC Annalise is with us too, so we can bring everybody over. We'll kind of restart here in a moment. I mean, continue. I don't think I have the power, Elliot. I'm sorry, right?
I've sent the invites.
Oh, did? Okay, yeah. Thank you. I'm going to say, please accept the motion in the chat. If you could redo Keenan, he has his hand up. Please, Jess, I'll say, please accept the motion. And I'll say that as well to Counselor. Counselor's there. Okay, great. That's a strange thing for someone to get on their second day. Ms. Jess Miller has just joined DLCD, and I just sent her a chat that says, please accept promotion. So she's probably thinking I'm insane. Okay, I'm going to go ahead and, since she can hear us, hopefully I'm going to go ahead and just continue with inviting folks to say for the record who you are. And I'm going to do a little of order of appearance here. And if it's okay, I'm going to start with federal. The tribes are the representatives of federally recognized tribes in Oregon are folks who asked the state to initiate this rulemaking. So if it's okay, I'm going to ask Counselor Anderson to go first, and then I'll do a little order here. If we could then hear from Courtney, with CT Clusie, also very early in the request for rulemaking, just looking down the list. Cassie, then who's participating via ODOT, but she was definitely there from the beginning. And LCIS will go Patrick next. And then we'll go local, and I'm just going to get in that regard, we'll go actually Alexandra next, as she represents many cities. So if that we could go Alexandra, and then let's go right down Ed Sullivan, Nick, and oh, I forgot Brees. So I'm sorry, Counselor Anderson, Courtney, Cassie, Brees. Sorry about that, Brees. Nick, and then Dave and Ed. And folks, please feel free to take a moment and say if you have any comments on the rules that you'd like to discuss today as you're going along. Jill, certainly there from the beginning because you're code and comp plan or presidential. Mr. John Pauly next after that. And just a few more folks. Let's see. Keenan, I got you over from attendees there. Thank you. Ms. Fitzgerald, Kimberly, thank you. And let me just see, pull my bar down here. I think that's everybody. So, okay, we'll go Counselor Anderson, Courtney, Cassie, Patrick, or Courtney, Cassie, Brees, Patrick, Alexandra, Ed, Nick, Dave, Ed. I think I've got a couple Eds. Jill. Moment. John, Polly, Keenan, and Kimberly. I think that's everybody. Counselor Anderson, could you like to come on and just say anything about the rules or at least just introduce yourself? Would be great. Thank you.
Hear me very good.
There it is.
Oh, okay, sorry about that. I'm going to be equipment. I do a little work. And with that being said, I appreciate the time to be here and participate, listening, and I think I'm going to just kind of listen. And I believe you said we can comment as we go.
Yeah.
And so, based on from the previous meeting, going over it, I think we have
Counselor, I'm cranking up my volume, but if you could sort of yell at us, I'd be grateful. It's a little hard to hear.
Okay. Well, good morning, Left Anderson, Clemens Drive. As you mentioned, sorry I'm kind of doing double duty today, doing some work in a piece of equipment. It's kind of hard to hear. I think I'll just comment as we go, and thank you for the time this morning.
Thank you, sir.
I apologize for my activity as well.
Thank you. No, thank you for being with us. Thank you. And I put the roll call in the chat there. Courtney, are you able to come on with us and say hello or anything you'd like to about the rules?
Yeah, Dai Galatikahais, Courtney Sinsanu, Lakleman Kukwis Milkau. Hello and good day. My name is Courtney and I'm the Tribal Historic Preservation Officer for the Confederate Tribes Kuslarm Coinsay Indians. And thank you everyone for all the work and time that's gone into this. It's very, very exciting to move forward. Thank you.
Thank you, ma'am. Cassie.
Good morning. Cassie Rippey. I am a tribal liaison with the Oregon Department of Transportation. My time working on the need to address these proposed rules predates my time at ODOT, predates the work that we're the convening of this group. I look forward to the conversation today. I do have a few things that I want to talk through with the rules, but I won't call them out specifically here. We'll get to them as we're going through, but thanks.
Cassie, thanks. Reese.
Good morning, Commissioner and everybody on this team. I like others have said, have really appreciated this opportunity. And I am the manager for the Historic Preservation Office and Deputy TIPO for the Confederated Tribes of Grand Ronde. I've really appreciated seeing the agency take such a positive step forward for tribal concerns. As Cassie just noted, this has been a long conversation, and really appreciate how responsive the agency has been in seeing all of this movement here. So thank you. Hi, Masi.
Thank you, Breeze. Patrick.
Good morning, everyone. Patrick Flanagan, Executive Director, Legislative Commission on Indian Services. I am filling in for Alyssa Bullion on this call. She got called out on an inadvertent discovery this morning, so she's asked me to fill in. I was involved in some of the earliest meetings, the very earliest meetings when this first got kicked off, and then I very wisely turned it over to more capable hands, those of Alyssa. So she's been our representative. Like I said, I'm just here to kind of observe hear what questions and concerns arise. I have had some outreach from at least one tribe about concerns on the burden that some of this will place upon the tribes and their cultural resources departments. But I'm mostly here to listen. Thank you.
So, Patrick, thank you. And thank you for sharing that. That's definitely talk about that today. And I thank you. I'll make a note of that. I might just take it up even before we get to changes in the rules. Amanda, if you can help me make a space for that. Alexandra, you're welcome. League of Oregon Cities.
Hi, folks. Alexandra Ring, League of Oregon Cities. I am very new to this whole process for this set of rules. I joined the league only last month, and this is one of the first rulemaking processes that I've been a part of at the league, and I've really appreciated kind of the openness, transparency, and just kind of the engagement in this process. It's been really wonderful to see. I look forward to seeing the final rules.
Thank you. Thanks for being here and joining us so quickly upon arrival. We're grateful. Mr. Ed Sullivan.
Hi, I'm Ed Sullivan, retired land use lawyer. I've had three comments on the rules. One is the placement of cultural resources vis-a-vis photovoltaic resources. The current version of the rule has photovoltaic resources over and above and trumping, if you want to use that word, cultural resources. I don't think that that should be the case, and I'm hoping that the commission will see that when the rules come down in final form. Secondly, I raised an issue of the designation process, and I understand that this may be mooted by a proposal to change those rules today, and I would support that change. The last thing is how to deal with evidence that is not generally available to the public by virtue of the public records law, and how local governments can deal with that in their local land use processes. I'll be watching and waiting to see how that issue is dealt with. But these rules are positive. It's high time that we dealt with this issue that's put off since 1996. I'm very happy with the collaboration of the tribes, with local governments, and with others to get these rules adopted. Thank you.
Thank you, Ed. Thank you for signing up for this. Appreciate it. Nick, please.
Yeah, good morning. Nicholas Starn. I'm a land use planner with the city of Portland. And I just wanted to give a shout out to DLCD staff, in particular Amanda, and broadly just the RAC, but the willingness to listen to the RAC and listen to our comments and actively work with us to create, to solve problems that we've seen along the way. It's been this hasn't felt like a rote process. It's felt like a collaborative process from my position, and I just privileged to be a part of it. And I think we've done some good work here. So thanks all.
Nick, thank you very, very much. And I certainly agree with your shout outs to Amanda. We don't go anywhere without her. Dave, please, Mr. Hennicutt.
Hi, Dave Honeycutt, Oregon Property Owners Association. I represent on this RAC the people that are going to be burdened and impacted by these proposed regulations. I have some questions that I'll raise later today, and unsurprisingly, concerned, especially with the significant cultural landscape features portion of these rules and how they apply and potentially how they could impact property owners that essentially have no idea that they're coming.
Mm-hmm. Thank you, sir. We want to move that right to the fore too, so we make sure we make space for that today, Dave. Thank you. Appreciate that very much. Jill.
Good morning. I'm Jill Ross, Coos County Community Development Director. I think I do share a little bit of Ed's concerns about how we treat things in the record. I think that's been a struggle for us in our process. So I'm looking forward to having a little bit more about that conversation. And then, with all the clear and objective standards that are coming down, just keeping those in mind. And I know we kind of had that discussion about like deeming things complete, incomplete, and I'm not sure we really sorted that out. So just want to make sure that we kind of have that in mind. Other than that, I appreciate being part of the process and having a voice. Thank you.
Jill, thank you very much. John, Mr. Polly.
Yes. Hello, everybody. I'm John Polly. I'm the state archaeologist at the State Historic Preservation Office. And I too am happy to be here and appreciate being part of this process. And I'm looking forward to some good discussions. Thank you.
Great. Thank you, sir. And then Keenan, welcome back.
Thanks. Keenan Orden-Bacallion. I'm a land use attorney with the law firm Schwabe, Williamson and Wyatt. Represent primarily developers in the building industry. Kind of share some of Dave's concerns here about kind of just the implementation side of this, because we're the folks that are really going to be, along with the jurisdictions, of course, dealing with the implementation side of this rule and how that interacts with development. So no specific comments at this point, but appreciate you all having me.
And thank you. Thanks for applying and being here throughout. Ms. Kimberly, please. Fitzgerald.
Hi, yeah, Kimberly Fitzgerald, the Historic Preservation Program Manager and City Archaeologist for the City of Salem. I am very grateful, as others have said, to have been part of this group. This topic, this issue has been near and dear to my heart for many, many years, and I've worked hard here in Salem to implement something that will help protect our cultural, archaeological resources, and have worked hard with the tribes to put that in place. I do have some similar concerns. My biggest question, I guess, and we'll be discussing it, it sounds like soon, is really about the implementation. And we've talked about it before, how folks who already have a program in place, how the rules will affect what we're doing or not. And also, I am very interested too in the next steps, and perhaps you're already going to talk about that. In terms of the technical advisory committee. So those are my questions.
Great, Kimberly, thank you. And that's it. Your segue to staff here, just real quick to introduce themselves, but we are, just a reminder, we are in the public comment phase. So we have received some public comments from jurisdictions so far, and that is to and through, I think, October 15th. When is that? Am I saying the right date? I've lost my little handy calendar. I'm lost with that. Here we go. October 15th, is that right? We say October 15th at the end of day?
I've seen 15th and 16th.
11:55 p.m. on October 16th.
Thank you. Thank you. With 15th at the beginning. Thank you, Katharia. Speaking of Katharia, don't go away. Katharia is our senior rulemaking coordinator, and we don't go anywhere with Katharia. So please, could you introduce yourself, ma'am?
Hi, good morning, everyone. Katharia Taylor, Senior Rules Coordinator for Land Conservation and Development.
Thank you so much, Katharia. And quickly, Amanda. Hope you're blushing, but come on in. We're not over yet. So
Amanda Punton, Natural Resource Specialist for DLCD.
Awesome. Thank you, ma'am. And Ellie, Gordon, please.
Gordon Howard. I'm the Community Services Manager for DLCD. I'll need to leave this meeting at 1.
Okay.
For another
Great.
meeting.
Great. Okay. Well, thank you for being here as long as you can. And then Elliot, who we're saying goodbye to, so there's a goodbye and a hello coming. So Elliot, can you come on and say, be recognized? Give us your title.
Hi, everyone. I'm Elliot Eastman. I still have to pull up my Outlook signature for this. How sad is that? I'm the Community Green Infrastructure Support Specialist, and also helping with the RAC support. So it's been a pleasure serving all of you. So thank you.
Yes, thank you, sir. And then this is a welcome to Miss Jess Miller, who is joining. Elliot had a promotion 10 months ago in January and has been helping do a couple jobs. Jess, are you available to come on and say hello?
Yeah, hi, I'm Jess Miller. I am the new Executive Support Specialist for programs for DLCD. And I'm here right now learning, drinking from the fire hose a little bit, but hopefully I will get to know all of you, and I'm excited to be here.
So thank you. So as we move into that next implementation phase, you'll be hearing a lot more from Jess and probably a lot less from Elliot. So Jess, thank you. Thank you. If I've forgotten anyone, please let me know. Really helpful just to hear everyone's voices as we dive in here. Again, public comment period to and through 11:55 p.m. on October 16th. And so Kimberly, it made me think of, City of Salem in particular, as you're raising that, might be worthwhile to huddle with you one-on-one because the intent is for the programs to be complementary and not redundant. So, we're still learning here. There's fewer jurisdictions with programs in place. So meeting with the folks individually is actually worthwhile as we make a staff recommendation to commission for their adoption on December 6th. So if we don't get to all of it today, let's definitely meet before the comment period deadline. Okay.
Sounds good. Thank you.
Thank you. Great. So just trying to come back to the agenda here. It's fighting me. I just maybe one more Thanksgiving for those who I know several folks were trying to come to the September 27th Land Conservation Development hearing. Councillor Anderson and Ms. Sarah Palmer were able to join from Klamath Tribes and Coquille Indian Tribe. It was several things were stacked in everyone's way. It was National Native American Day. Hey, Carrie, come on in. I'm just going to stop talking. Carrie, welcome. Did I just say hello?
Stop talking. I was just trying to be quietly, slide in here. So, sorry. Welcome, everybody. Thank you for taking the time today. I'm Carrie Miller. I serve the Confederated Tribes of the Umatilla Indian Reservation as one of their senior archaeologists. I appreciate DLCD hearing our concerns. I appreciate this process. I think I'll interject as we move through. I guess some of the concerns are, how do these resources get added to like the list, and how are we going to incorporate these Goal 5 resources as we move forward if we're not doing a UGB or something large. So still, I think I need to get my head wrapped around that, but I appreciate everybody's time and their willingness to be here to work on these important matters. So thank you.
Thank you. Thanks a bunch. So just thanks to folks for coming on at the hearing. Feels like last week, but I think it was a week and a half ago. Now, lots of boulders in folks' way, emergency school closures, lockdowns, National Native American Day that we inadvertently scheduled our meeting on. So several offices were closed. So just thank you to those who were able to attend. Very powerful for the commission to hear directly from Rules Advisory Committee members. Ed, I'm sorry, I omitted you, Ed, there. Ed also attended and provided testimony, so thank you. Really appreciate it. We do have housekeeping. We have one more open house left, sort of open just drop-in session. And Elliot, if you're able to put that in the chat, I'd be grateful. It's just informal time for people to come together and talk about the rules, and it also made that one too. So if we don't have time to discuss items today, that we can definitely consider that overflow time.
I apologize, Kirsten. I was doing two things at once. Can you repeat the thing you let me put in chat?
Yep, the next open drop-in date.
Okay.
Thank you, sir. Okay. So with that, I think we're ready to dive into potential rule changes. I'd like to kind of start, I know it's going to throw you, but I'd like to start with some of the other that RAC members have raised, if it's okay. Before we're going to have a 12 to 12:30 break for lunch. And we have some things that I think are more straightforward, but before that, Dave, would invite you to come back and just talk a little bit more about your concerns around kind of property owner awareness. The one thing I would say by way of intro, if I could, is that, we're open, first of all, we're open to hearing how we can help get the word out best, whether it's also through, real estate professionals, organization, any other trade and industries groups. Happy to provide, one-pagers, guidance, webinars to help get the word out. And then also, as you, I think folks know, there's a notice requirement that would go right with the development application. So folks would be getting that information, at least on inadvertent discovery, right? Right as they're kind of pulling their permits. So Dave, would you mind coming back on and just sharing a little bit more of your concerns?
Yeah, sure. I guess more of an applicability issue than an immediate notification that the rules are being enacted and that people need to pay attention. What concerns me is what happens as these rules play out as a county, because this is I think it's fair to say this will occur rural and urban. And so we see a county faced with an application to declare a specific piece of private property as a local and place it on the local inventory of significant cultural landscape features. I'm not exactly sure how the application is initiated, if the county has to initiate it or if it can be initiated by anyone. And I can see it being targeted at a specific property. So although it may be legislative in nature, it's really a quasi-judicial application targeted at a specific piece of property with, as I understand it, the property owner not being notified of the fact that this application is going on. And ultimately, with a decision after an EC analysis being made that enables the county to not only limit use of the property, that's one thing, but also to provide. Oh, I'm looking for the language. Establishment of time windows when access is restricted to members of the tribe or cultural group engaging in the activity from which the basis of the site significance is derived. So essentially, not only are we limiting property uses, but we're also essentially, the local government would be giving access to a particular tribe onto private property, which raises all kinds of interesting constitutional issues, which I suspect that my organization would probably take charge on, because this would be a significant problem, and so given the lack of specificity of a definition of these areas, coupled with a lack of property owner knowledge, coupled with some really significant implications on the ultimately not just the use, but the ability of the property owner to determine who gets to come in and out of that property, which is privately owned. This is potentially a big problem for us.
They've understood, absolutely, and I think those are examples, of the potential limitation. So you're right. It's particularly hard to write rules for a scenario in which no one knows yet. Amanda, or Gordon, do you have any kind of immediate thoughts for Dave? This is all, of course, subject to a public process, Dave, but I think I would like to ask Amanda and Dave if you have a handle on it would be hard for me to imagine that the notice could be made without the property owner being the first to know, among the first to know. So whether it's quasi-judicial or legislative at the local government, what would those notice requirement be of the property owner? I would think would be relatively immediate. But if that's not the case yet, we should make it so, or work to make it so. We don't have the authority, else the commission does, but we should make sure that those who are, it's the nothing about us without us principle. So certainly would want to make sure that property owners are in the immediate circle. Amanda or Gordon?
Gordon, you came off mute, so start.
At some point in the process, the property owner would receive undoubtedly quote unquote measure 56 notice, because that's required by state law. I think a good question, Dave, would be whether that notice requirement would be triggered, the statutory notice requirement would be triggered by the comprehensive plan amendment as opposed to the implementing zoning, which is definitely where it would be. So I think we would need to, that's a good question though, in terms of when that notification would occur, because clearly the property owner, if someone other than the property owner were applying, was submitting an application for a protected area landscape feature, we would want the property owner our rules to require the property owner to be notified as early as possible in that process. In fact, when the application was originally submitted by someone.
Well, Gordon, if someone can submit an application, then it seems to me that this is quasi judicial. I've never seen a county development code that lets anyone other than the applicant or the applicant or the property owner or the property owner's representative submit an application for a quasi judicial application on a piece of property that is privately owned. So who gets to submit the application here?
Right. That's actually a very good point. I think the way the rule is written, someone could, who is not the property owner, submit the application without the consent of the property owner. And presumably a landscape feature, although it doesn't have to be, would be over several properties. And I think you're right. It would be fairly specific, and it would be a quasi judicial application. There's nothing. That is a very common practice for local governments to require the property owner to consent to a quasi-judicial application or sign off or whatever. But it is not, to my understanding, unless you can point me to something different, a state law requirement. So there could be a situation where some sort of interest group applies for a landscape feature designation on a property as a quasi-judicial application without the property owner's consent. But we would want to ensure certainly that the property owner was notified. I would think the local government would do that as a matter of course, but I think we would want to put something in the rule that requires notification at that point of the property owner if the property owner is not the applicant in that situation. This is pretty unusual from the way things are normally done in local governments in terms of quasi-judicial applications, and that normally, you're right, a local government doesn't allow a developer to apply for a subdivision on a lot on a parcel without the property owner having signed off on it. So this would be a break from standard operating procedure for local governments, certainly.
Well, and Gordon, is it the department's position that we're going to allow county governments to start to decide if there's a cultural landscape site on a property, to decide and to allow folks other than the property owner to control who gets to go into that property and use that property? Is that the department's position on what these rules say? I think that's what they say, but I just want to clarify and make sure that I'm reading them correctly.
Well, if that's the position, if that's what they apply, then that's not correct. We don't have the right in our rules to abrogate a property law in terms of ingress and egress and things like that. So we can, if you want to point to something in particular, we can look at to make that clear. But I mean, even if it's not clear, we have no authority as a state agency to allow to restrict someone's property, ingress and egress and use of a property other than through clearly, there are restrictions in terms of use, in terms of new applications and stuff, but, everyday use of a property, we have no ability and don't want the ability to tell a property owner how they can use their property on a regular basis.
When Dave, if I may, the idea is for a conversation. Anything else I would say would probably just muddle.
Yeah, because we're talking specifically about the landscape areas of cultural significance, not about archaeological sites. Certainly what we have for archaeological sites is about having the conversation, and our rules would just apply, would bring recommendations and help support application of state laws and rules pertaining to archaeological sites. In this case, the all protections for a landscape area of significance would be local, and One thing that wasn't mentioned was we'd started off thinking that the applications for these landscape areas would be similar to how someone comes in, applies for an aggregate site, right? And of course, they do it with the property owner's awareness and consent. But that's also run through a quasi judicial process. The reason why the idea was put into the rule to use the judicial process is because there's no timeline on that. And we thought that a local conversation and process to add a site, and then certainly the discussion about what it would mean to have that site be a significant site and a protected site would need more time than the 180 days, or not 180, 120 or 150 days. But this not new concern, but just what I'm hearing for the first time, we'll certainly need to address with regard to property owner consent. I guess I've been thinking that the laws that exist outside this rule will certainly apply to whatever local government attempts to do or tries to do or does do with regards to protecting a landscape area. And the ESCE process would private properties rights and intentions would weigh pretty heavily, and economic considerations would weigh pretty heavily in that ESCE decision-making process.
Reese, thanks for your note. Would you like to just chime in?
I see Jill's hand was up before.
Oh, thank you. Thank you. Please, Jill.
I guess I don't understand when you do the landscaping feature, why wouldn't that be something you would add to your inventory, which would trigger a plan amendment? And that way you don't have the timelines and it follows that process. Plan amendments don't necessarily trigger specific property owner. I mean, you have to provide the notice to the property owner, but you do it in the way you would do any plan amendment where the county would, so we've worked with the tribes before to update sites, and, they've applied by just providing us the information, and then we went through the inventory process. So why wouldn't you do it? What's the hesitation of doing it kind of in a similar way so that it kind of alleviates that concern that you're not, you have to provide the Measure 56 notice.
You guys, let's look at the specific section. So to ground ourselves, we can.
It'd be
There's kind of a
sub
version of
six.
the rule where I've removed the underlines. Would you like me to share that?
I'm a fan of the actual.
Took the actual one and then just removed the underlines.
Yeah, but that it helps people see what's new and old, because we're with practitioners here. But you could share yours, and I'll bring up mine locally and put it in the chat. I mean,
Yeah,
not mine. I'll put so just to be clear, what I'm going to put in the chat is the Secretary of State notice that shows the track changes and underline. Amanda's in a version where as if it were real, and that's what she's going to show.
The whole entire rule is new, so it all
has underlined.
Secretary of State has underlined. I just find it hard to I don't see it as well that way, but
go ahead, please.
Yeah, so if I can, building on Jill's comment, that I think that we're seeing two things getting conflated. The first is the inventory, and then there's an access issue. And keeping it in sequence, I think that having a knowledge of what's out there and running through that process, and then each landowner, which seems to be at the crux of the conversation here, then their individual concerns can be addressed. And the most analogous thing that I could find off the cuff is historic cemeteries, which is about getting permission from the landowner with the ability to work in reasonable times to be designated by the property owner for visitation, maintenance, research, etc. That is in essence what we're talking about here when we talk about the intent of a tribal community accessing, and that is a negotiation between parties, not necessarily wider afoot. At least that's been how I can see that being addressed in a reasonable manner that doesn't look like creating something altogether new. It's already in place. So thank you.
So Bruce, just one question, quick question. That process takes place outside of a land use process, correct?
It does, but in the land use would have the inventory. The inventory, as you point out, would then have it, let the landowner know, you may not know that you have a historic cemetery on your property.
Right.
And because it comes up through the inventory. And in that you have responsibilities, obligations for access for descendants, etc., to be navigated in negotiation. And what this would do is create that space and that path. So that's where I'm going with that. Does that answer?
Yeah.
But I think your point about you have to know first. And that kind of gets to, I think, the latter part of the agenda about implementation and, how to actually make this all work.
Thank you.
Awesome. Okay, so Amanda's sharing, if you're bringing it up at home or at your work, page 8 of the filing notice is what Amanda has up there. So it's that subsection 4 in the middle of page 8, which is 4, local inventory of significant cultural landscape features. So Amanda, thank you for bringing that up.
We've also talked about section 6, but this is the section where it says specifically the application be treated as a what's not quasi judicial, but
legislative. Yeah,
legislative.
Yeah, this is
Here's the problem, Amanda, and I don't know the answer to this, so maybe somebody else in this group does. If you are letting under 4C, if you are letting somebody besides the county initiate the application process for the determination, and it applies to a single property or a small group of properties, I don't think it's a legislative amendment. It's a quasi-judicial amendment. And so I think the first thing that needs, at least that I would appreciate sorting out in my mind, is who gets to submit an application for one of these. Is it the property owner? Is it somebody else from the public? Or is it just the city or the county, the local government that has jurisdiction? Are they the only ones that can make this call?
As written, doesn't it imply only a local government can do it? I mean, only a local government can initiate a legislative amendment.
Is that Nick speaking? Yeah.
Yeah, I'm sorry. Yeah.
All right.
Isn't that true?
Well, in
So
the norm
process
course,
and application.
yes.
So Nick, my only in 30 years, I still have limited experience with this one aspect, but it was during your city's update of the comprehensive plan, and it was the West Quadrant Plan process, I think, and associated comprehensive plan changes.
Yeah.
And it was actually Riverview Cemetery. Speaking of cemeteries, wanted to change the zoning on several of its properties, so more than one property, and it applied for a legislative action during that time. So again, that was a private property owner, just happened to be a cemetery, but private property owner asking for a legislative amendment because it was more than it affected a zone and not just a few properties. So that's my limited experience, but I'm glad we have other local governments on the call, because it is possible that local government procedures vary on this. And Dave, albeit that was in a city and not a county.
Is Gordon, Still on
Yeah, if I could just
Cook.
break in here briefly, Keenan's note is appropriate. He did say, it's a difference between initiate and process, and this does say process. And I think the idea was that you would have potentially a tribe, for example, or tribal government, submitting an application for an amendment to a comprehensive plan to add a site to a Goal 5 inventory as a landscape feature. And that site might be one property, it might be many properties. And I think Dave is raising a legitimate question about whether this would in all cases be a legislative amendment. There is a court test. I forget the strawberry four-wheelers test, I think it's called, in the Supreme Court, which gives a way to differentiate between legislative amendments, which are, to a broad number of properties, don't have to take action. There's various, it's a rather nebulous test at times, versus a quasi judicial application, which applies to a very specific area and is bound to reach a decision. So I think this is something we would at the department need to look at a little more closely, whether these would always be legislative amendments. But I think to clarify, the idea was that it would not. I think Keenan is correct. The local government shall process an application if they submit it. If it doesn't mean that they're the submitters. You could have a tribal government, an individual who's not the property owner, a group that's not the property owner, a group that owns some of the property but not all of the property. A lot of different options of people submitting it, and the idea was that that the city or the county most likely would be required to process that application if it was submitted to them.
Thank you, Gar. Thank you both. That's everything you've said, and Amanda, thank you for pointing out and shading, and Keenan for pointing out something about what you're about to say there in the chat, probably. Keenan, please.
Thank you. Yeah, I think Gordon, you're spot on there. I think there is a distinction there, and that kind of goes to Dave's point about who exactly can file these applications, right? I mean, I understand the intent certainly is for the tribes to be able to file these applications based on the fact that they have the experience therein, but it's not limited to just the tribes. And I think one of the concerns that I have in particular is kind of how this is actually going to be implemented on the ground and whether this can be used in a manner that's not necessarily intended. And so that's kind of where I'm trying to find out if we can put some sidebars on this a little bit. Yeah, I mean, I don't want to be the harbinger of doom here, right? I have no idea how this is actually going to shake out on the ground, but I wouldn't be doing my job if I wasn't concerned.
Yeah, no, thank you. And I think, to be fair, Dave raised this a couple of meetings ago regarding, the fundamental question of who could bring it, Dave. We recall that certainly. And we discussed whether or not it would be, limited to federally recognized tribes. And the sentiment of the group at the time in discussing that was, let's keep it open. But I recall your concern, and don't know if you have anything else to add there. Commissioner Thompson, CIC liaison, what are we? Land Conservation and Development Commissioner Leanne Thompson has her hand up. Please, Commissioner.
Thank you. Good old what's her name and whatever her role is. So I have concerns just as an interested county commissioner, not just speaking as in my role as LCDC commissioner. My neighbors like to work mischief on each other for any reason or no reason. I mean, I have calls all the time with people just giving each other grief. And I want to hope that we don't add to the consternation that exists in the world already. I want to be thoughtful. I want to honor what needs to be honored. We're doing a process of change, which always involves loss and negotiation. To the extent that we foster negotiation and reduce opportunities for gratuitous grief, I'm for that, just personally. Thank you.
Susan, if I could add something briefly, if you'll notice back up to the section about the significance, we did have the discussion about whether to limit the application of this only to, to try, tribal governments or tribes to submit these applications. And, it was suggested that others should have the ability to do that too. But that language does say, have a sentence saying a local government shall consider a tribal government an authoritative source of knowledge. In other words, it's kind of a rebuttable presumption that the tribe knows what they're talking about when they submit the application. That presumption is not given to other groups. For instance, a group of hunters or fishermen who just say that this area is significant to them for cultural reasons, or who knows what, and maybe some of the mischievous things that Commissioner Thompson's talking about. But it does allow those applications, but it doesn't require the local government to give deference to the reasons for those applications when processing. And also, this language does allow the local government to set, I believe, doesn't have any limitations on the local government setting processing fees and things like that would hopefully prevent frivolous applications from being proposed to some extent, at least.
Folks, thank you. I want to just do a quick time check. We were all we're all in the midst of this, and I think we can continue it for a bit after lunch, but I want to just remind us that we're going to take a hard stop at 12 to try and do the good behaviors of having a lunch break. I want to appreciate several members of the RAC who reminded me of that. And then we'll get back on at 12:30. But I just wanted to warn about that, and also to welcome Peter Hatch, who typed in the chat that he's kind of heading into a bad cell zone, but will rejoin. Thanks, Confederate Tribes of Siletz Indians, and also Brandy Knudsen from Cow Creek Band of the Umpqua Indians, who's in attendee mode. Brandy, you're always welcome. And then also Sarah Palmer. Thank you, sir, for joining from the Coquille Indian Tribe. Dave, do you want to give us any last thoughts before we adjourn for lunch and give us all some more to think about? But I appreciate you raising this discussion today. Very important.
Well, and I appreciate all of you in indulging this, but this is obviously for the interests of the folks that I represent on this RAC. This is one of the key, if not the key issue. And what scares me is the mischief. And if this is introduced, if we allow quasi-judicial applications, because, if we allow someone other than the county to initiate this process, it's going to be, in all likelihood, a quasi-judicial application. And then we go down to Section 6 that Amanda referenced, but we haven't gone there. As part of the county's EC analysis, the county or the city is empowered to essentially start controlling when and how the property is used, not only by the property owner, but when and how access can be made by the applicant, which, if the applicant isn't the property owner, again, raises some pretty significant constitutional issues. And so I would suggest that, and I'm happy to help, and Amanda and I have already talked, and I'm happy to continue to help. But I would suggest that you take a pretty strong look at that, because I completely share Commissioner Thompson's issues with this. This is going to be used as a sword, not a shield, by people who are not who the rules are not intended to protect.
Thank you, Keenan.
Yeah, really quickly here. Gordon, just on your comment about the tribes being an authoritative source, I understand that piece, but if I'm not mistaken, it seems like not only can these landscape areas of cultural significance be designated for tribal importance, but other importance as well too. So the protection or the presumption there that pertains to the tribes, if it's a designation that has nothing to do with a landscape area of tribal significance, that presumption wouldn't necessarily apply in this case. So I am still concerned, I guess, on the mischief piece as well there too, for areas that don't have that presumption of tribal expertise involved.
Thank you, everybody.
Can I just jump in, and I just want to point out this, and Kirsten, I think you mentioned it before, that the list that is concerning below was really just, I don't know if you remember this in the RAC meeting, but I had been asking for just ideas, and I didn't really get input on what to put in this section to kind of flesh it out. And so I just used what I remembered from previous conversation about what is important, what we've heard from our tribal representatives about the sites. And so this just says an ESE analysis shall include consideration of, right? And that's just so that these potential strategies are discussed or considered in the ESE analysis. There's nothing here that says that these protection measures will be the outcome of an ESE process.
Very good. So on that note, I would just like to invite Nick to share concerns. So we gather all the concerns that we know of at the moment before we head into break, and then, but also Sarah has her hand up. So Nick, just quickly, if you want to touch on your note in the chat, and then I'll turn to Sarah for last word before lunch break.
Well, yeah, I mean, if I'm following this, I guess I must admit, at the city of Portland, seeing that word legislative led us to believe that this was an optional program that a local jurisdiction could create to protect landscapes of significance. We weren't thinking of it as something that a property owner or a citizens group or a tribe would come in with a proposal that the city would then have to consider adding a property to an inventory and instigating a program to protect. We were thinking this is a great opportunity for local jurisdictions to create programs, and the program would be created and have a plan amendment and set up a program to create it. So if in fact what I'm hearing is correct, that this is something that someone could just come in with whether it's mischief or actually legitimate, wanting to protect it's a change in the way we thought about it, and I need to bump this up in terms of maybe submit some additional comments. So I want to make sure I'm understanding the issue.
Nick,
Yeah.
I think you are understanding it correctly. Sarah,
Yeah.
before the lunch break, please.
Yes, good morning or good afternoon now. I won't hold you because I'm sure that we're all ready to get to lunch. But as we head into that break, as a long-term cultural resource management practitioner in the state of Oregon, I appreciate these concerns that folks are raising, but I'm going to be honest with you. This isn't something that I have seen arise as a problem, and we have had parallel processes both at the local government level, as far as designation of historic districts and landscape areas, and also at the state level in the national register process for decades. And actually, I've seen it going the other direction, where we have more people who don't want to see protection and take malicious action to prevent the protection of resources that many others in their communities feel are important. So I would say that I've actually seen more of the opposite of what you're concerned about, based on my experience. The other point that I would like to make is that because we have that existing both the federal regulation has sort of devolved down into the state regulation in Oregon. And it is really critical, and this is a point that I've raised to our DLCD colleagues a couple of times during this process in our separate conversations, maintaining that consistency with the existing legal context is really important when we're thinking about the defensibility of this rulemaking process. And there is a point at which, while innovating is always, a delightful thing to do, we do want to maintain that defensibility. We want to maintain that consistency, because when we get into saying, well, we're going to privilege a group in a way that is not anticipated by state or federal law and existing case law, we do create those issues where we lose that defensibility. And it would be unfortunate if after the investment that we've all made in this process, we reached a point where we didn't achieve that. I always think that's a critical piece. So I guess that would be the perspective that again, as somebody who's been doing this for quite a while, I would offer to the group. I do understand that shenanigans will go down. Shenanigans go through my inbox literally multiple times a day. But on the other hand, that's also kind of something that all of us working in government are used to dealing with, and we can't prevent that. You know, citizens are going to people are going to people are going to be made of people, and you cannot build a government system that is going to defeat the tendency of human beings to be people. Frustrating though that is for many of us on many days. And I just think that keeping that defensibility, and also keeping in mind, uh, you know, maybe we try it. And if frankly, if it does end up being a subject of consistent abuse, well, it's not like we can't come back and have more conversations. But I would say my own experience, looking back to like sitting on the Eugene Historic Board for 9 years, was that I more often had problems with people wanting to demolish 150-year-old buildings than we did with people maliciously listing their neighbor's house on the historic register, which wasn't permissible anyway. So anyway, those are my pre-lunch thoughts, and I look forward to rejoining in a few minutes. Thank you.
Thank you, Sarah. And I would be remiss if I didn't channel Director Bateman. She's reminded all the rulemaking teams throughout her tenure that if it's we make a big step, we make a step, and if we need to come back and revisit, we would take that back to commission. So that is always an option, as Sarah said. But let's try and make this as good as we can get it. Let's continue the discussion at 12:35. And if you're bored over the lunch hour and you haven't submitted a letter of public comment yet, I would invited you to just start writing down some thoughts, because we love things in writing. They help us. So you do have until, what is it, you guys? Let me get it right. October 16th at 11:55 p.m. So thank you guys. Have a good lunch break. We'll see you soon. We'll keep the channel open. Thank you. You can feel free to go on mute and off video. Thank you. Hello, everyone. Coming back in. Thank you for the time to make dinner.
Thank you for the break.
Great. Okay, just watching for folks to come back. Got Amanda. I know we have Commissioner Thompson. Go ahead and come on camera, folks, if you're able to signal that you're back or say hello. You don't have to come on camera if you're rightly eating, but I want to make sure a few key folks. There's Dave. Good. Thank you. Carrie, thanks. Okay, well, we wanted, okay, great. Jill, thank you. Hey, John, thanks, guys. So, Amanda and I had a chance to just huddle quickly over the break, and we wanted to clarify a difference between statute. Amanda put this in the chat before the break, but Amanda, do you want to go ahead and just mention about the statute on historic resources that's different from cultural areas, landscape areas?
Sure. Yeah, and I put that in because I was struck by Sarah, your experience of of local protections for historic resources going relatively smoothly. And so what I said, and I probably over the break should have looked up for the reference, but in statute in Oregon, a property owner needs to consent or at least not to object there to a site for protections being put on a site of historic importance. And there's a similar thing on the National Register where if 51% of property owners involved in an historic designation object, then a site won't get listed on the National Register. So those accommodations, I'll call them, for property owners don't exist for a cultural a landscape area of cultural significance as we've described that in this rule.
Right, and just making a note there, but it's quicker to say it out loud. Elliot, if you don't mind bringing over RAC members who'll be willing to come over from attendee to panelists, that'd be Nick, Brandy, if you're willing, Kelly, Curry, Nolan, if you'd like, and Peter, and Jess.
I apologize. I had to step away to get something to my son's school. So I think Cassari can do that right now. I should be back at my main computer in about 5 minutes.
No problem. Thank you. Family first.
I'm
Thanks,
working on it.
Casaria. Thank you, ma'am. Cool, cool. Okay. And yeah, Amanda, I think just thank you for that clarification. We definitely have, yep. Nick, we're bringing you, Casaria's working on bringing folks over for sure. I think, let me just check on that real quick. We've got Brandy may want to stay just in listen mode. Nolan may just want to stay in listen mode, and Peter's come over. Okay, great. Thanks, you guys. Thanks, everybody. Okay, doke. So this was a really important discussion we just had. Just to recap for folks just joining, we were talking about sections 4 and 6 in the draft rule. And I can, it should be still in the chat, or I could put it again in the chat for folks who may have joined later, but the local inventory of significant cultural landscape features, and also section 6 related is protection of landscape areas for cultural significance. And, I think, we've agreed that DLC staff will look into, case law and the court tests on what's legislative amendment versus quasi judicial. We have that as a homework. And then we also have, this fundamental question of, whether or not to put any limitations on a landscape area of cultural significance. Keenan wasn't necessarily recommending this, but in his remarks, Keenan used the term landscape area of tribal significance, which kind of does indicate then it would be of tribal significance, even though the rule currently does reflect that tribes are the authority or an authority on sites that are important to them. And again, we've not set up the RAC as a consensus body, so we don't need to achieve consensus today on these questions, but they're very good discussion. And Dave, I'm grateful for you bringing them to us here, so we can, really consider them, take it to our director, and then raise it for commission. And I'm grateful for Commissioner Thompson being at all the meetings so far, helping be a liaison with the commission as the commission makes a decision on this in December. I know we have a host of other things that Amanda had queued up to talk about. So, Dave, I might just ask if you have anything further you'd like to say before we put a pin in this important discussion. Dave, do you want to be able to say anything at this point? You want to make any final? Okay.
I think we all know what the issue is.
Yeah.
And I'll write it up and submit it as a comment.
Thank you. I know the staff and commission would appreciate that, sir. Thank you. Okay, you got it. How many days? 8 days. Sorry, thank you. Okay. Okay, Amanda, I think to loop back, just welcoming everyone back, Amanda's going to take us through some potential rule changes. We've had the benefit of several communities, cities, writing us comments on the rules, and Amanda has a short host to bring forward. We might start with the one, Amanda, that City of Portland had brought forward, if you're able to start with that one.
So with that, I'm going to share a different file, although people who looked at the agenda earlier, I realized as I was amending this agenda, this item got left off, so I stuck it back on, which is an interest in making a provision in the rule for local governments to have protections for archaeological sites that are of non-Indigenous origin. Right now, the rule does have the provision, if you remember, Section 8, for how a local government to tribal government agreement can take the place of the parts of this rule, the notice requirements of the rule that apply directly, which is what we're calling our protection for archaeological sites. But and let me touch for 1 second, because Kimberly, you brought up a lingering concern about existing local programs, and adoption of a new rule can't take away an existing local program, although I'm assuming your program is adopted into your code. If it's not into your code, then I don't, and same with City of Portland, although I think they are adopting their code, I just don't know what their origins are. But generally, a new rule can't change anything that's in a local code or change the application of something in a local code. So I'm going to stop sharing this. And Nick had mentioned that we've had some conversations around how we might add something to the rule to recognize. Are you seeing my screen now? It looks like a PowerPoint slide.
Not yet, Amanda. It's not yet.
Okay, let me go back here. Did that too quickly. Share screen. Share. All right.
Thank you. There it is. Thanks.
And so just organizationally wise, my thought is that we expand Section 8, which is the one that talks about government to government programs, but expand that to create a place for local protection measures that apply to non-Indigenous sites. And so this is the examples that we have, or I'll just say Portland right now, that additional protections is that the city in some areas can require an applicant to do a survey of the site to get a better understanding of what archaeology might be there on the site. And so that's with that idea, that's how this was written. So as an alternative to the baseline protections in Section 5 here, actually, I can share it like, does that work if I share, no, it doesn't. I'll just leave it this. Does that work? Can you see the slide bigger now?
Yes, thank you.
So as an alternative to baseline protections in Section 5, A local government may identify areas with a high likelihood of containing archaeological sites and require pre-construction surveys within areas identified pursuant to little I right here. And then this part really kicks what protections might be for it after those those areas are identified, kicks it to the standard process. So local governments may limit development to protect an archaeological site identified through a pre-construction survey, provided the ESE decision process, or I wrote this kind of weird, through the ESE decision process in OAR 660-23040, or provided that is that standard goal 5 process step is followed. And the program to achieve protection is consistent with the directives of 660-23050, and that's the process step that basically says that the local code provisions need to be consistent with the ESEE findings. This language might not be perfect yet, but I guess I just want to hear if there's anybody on the RAC that has objections to adding this type of provision into the rule.
And Nick, do you mind just mentioning what comes up for you in this for the city of Portland? I think you and Amanda have had conversations that we haven't talked about, and I wonder if you'd like to share anything with the RAC.
Yeah, this language has evolved even since the last time we spoke, Amanda, and I'm liking what I'm seeing. I mean, this came up in conversations we were having locally with historic preservation staff and others, talking about examples like a Chinatown or something like that, or a mining district in a rural area where tribes may or may not have a particular interest in that would lead to a consultation program under Section 8 or whatever. So this looks to satisfy our request to just open the door for a new local program that could look at identifying and protecting non-Indigenous resources. So I think this is, I thank Amanda for this, and that from our perspective, this looks good.
Kimberly?
Yeah, I agree. I think maybe I do need to schedule a time with you, Amanda, to talk more one-on-one and with DLCD staff just to talk through how Salem's program might work with this. But by my first read of it, I mean, we do already have a cultural resource protection zone, which then is what is the basis, and it seems like that it would cover this. So generally I support it, and I appreciate your working on it. Thank you.
Curry?
Thanks, Amanda. Thanks for your attention on that.
So I guess I have a question about alternative, because so I guess this is saying that the local government can identify the area. So does this mean if it's not a known archaeological site? And so then they can do this alternative?
Let's see. So it's alternative because right now, so the baseline protections are providing yeah, I think we do need to work on that, right? Because we still would have tribe notices to tribes.
I mean, maybe instead of alternative, it's like in addition to the baseline, because if it's a known archaeology site, even if it's a Chinese thing and not related to Indigenous tribes or their interests, but they also may be interested in that because there's a lot of history going on there. They still need to follow state law if it's an archaeological site, whether it's Indigenous related or not. So just the alternative feels
Yeah, this
uncomfortable
was
to me,
going,
and maybe John can jump in. That's my only catch there.
so
right,
this
thank you.
was, so I guess, so this would be written into the rule specifically for archaeological sites of non-tribal origin. And like I said, it's not perfect yet because I haven't actually tried to work it in with 8. But once I do that, that's completely the intention, because right now there's nothing in the rule that would allow a local government to have this additional protection strategy. So however it is, the completely the intention is to allow for an additional protection strategy that applies to archaeological sites of non-tribal origin, and still that wouldn't be affecting the archaeological sites of tribal origin, which would mean that the only way you could relieve a local government or local government could relieve themselves of the notice requirements for sites of tribal origin is through the government to government agreements.
A couple of folks with their hands up. Amanda, Kimberly, I think you're first, and then Nick. And then Cassie also said in the chat that she concurred with Curry's clarification.
Did John go? Did John?
He put his hand down.
Oh, John, no.
Curry already said what I wanted to say. So
yeah, I think, I mean, I can draft, I'm working on a letter anyway, so, and maybe Amanda, I can craft. I think the intention, at least from the city of Salem's perspective, is that word alternative is important to me. But within the context of maybe some additional language where we're demonstrating that we're achieving the baseline protections just in our way, so it's allowed through the language. It's not like we're not meeting it because state law requires it, but that we have a program that threads the needle differently. So I'll work on putting some language in writing to you. But again, I appreciate the intent here.
Kimberly, thank you. Nick, please.
Yeah, I just want to say conceptually, and this, I know I guess I would be fine with it not be like the language being in addition to rather than alternative. Frankly, from a implementation strategy, it's going to be easier to just notice everyone all the time, set up a system to doing it, rather than carving out little areas where we have a new program and we're doing it, then, oh, we don't have to send a notice. So, but we have all these other different protections. So I think it might be fine to just have it be in addition to, and I don't have any problems with tribes getting notices about something going on in Chinatown. The other thing too, though, is I'm sensitive, Kimberly, to your concern about existing programs, but I think it's important, correct me if I'm wrong, Amanda and others, this is talking about new programs. Your old program was adopted as a plan amendment, and these rules don't change that. So I think it's conceptually different that this is creating an opportunity for a new program that would be created under new OARs from an existing program that these OARs are not changing in any way. Is that the right way to think about it, Amanda and others? So that wouldn't need the alternative to, because it's not really applicable. It's not an alternative to your existing program. It's an alternative to what's in 5, which is a new thing.
Right, and an acknowledged plan and code, they apply as long as they're not in violation of state statute.
Yeah, so I had that concern, or the city had that concern, Kimberly, and my concerns were allayed about existing programs. I'm focusing on trying to set up, flexibility for the future programs, and I like the way this is going. So thank you.
Thanks. I just put Carrie's for folks who are in attendee mode, they can't see for the stream. If anyone should watch it later, please, if you want to write everyone, just hit instead of host and panelists, write to everyone so that folks who are in panelist mode can see it too. But I just put Carrie's there as well, because I think Sarah, you put yours to everyone. Okay, yep, thanks. And then Cassie, please.
Yeah, thanks. I agree with the points that Carrie and Sarah were making in the chat. And I just want to provide a clarification. I guess in what I had understood the alternative things to be when we'd originally been talking about alternative options in coordination with tribes, I had understood that to just be these are some ways to coordinate with tribes, not necessarily I guess that my concern is the way that this is phrased right now is that it sounds like the county jurisdictions or cities are going to be deciding, oh, well, this is a tribal site, this is a historic site, this is a Chinese site, and parsing those things out. And the local jurisdiction staff don't, for the most part, have that expertise and shouldn't be making those determinations. I had not understood that when we said we were going to be offering ways for county jurisdictions to create an alternative process. I didn't know that we were designating that specifically for tribal resources. And to the point,
and I think I agree that that's a mistake. So that was a mistake in how this language was put together, how I put this language together. It is not intended to take away the that's why we just changed it from as an alternative to in addition to, because the baseline protections are largely about, or they really are all about communicating with tribes. So those would exist, they would continue to exist unless a tribe or tribes works out a better situation with the local government, signs a memorandum of agreement, and then they can follow their memorandum of agreement and not the baseline protections. But with the simple or astute change from in replace or whatever it was before as an alternative to in addition, we now have retained all of the notice requirements to tribes unless a tribe works out a different, better scenario with a local government.
Just a point of clarification. I think that Amanda, in your green kind of bar on the slide, it still says local option for archaeological sites of non-tribal origin. I think that won't be a header, right? That's just your nomenclature for this solution.
No, well, so if I stop sharing here and I go back to the rule.
And John has his hand up too. It's John, just one sec, if you don't mind if we clarify.
That's how I do it. I did that.
I just wonder if tribal representatives are saying don't distinguish in the heading tribal and non-tribal. Like you can have the alternative process, but you don't have to distinguish which cultural group it's quote unquote for.
We already have a very we've already spelled out how to address tribal, and I'm sorry, I'm just not managing my buttons well. So now I need to stop. Why am I? Okay, I know, I get it. I get where I am. All right.
Just don't leave the meeting.
Sharing screen, right?
That's my favorite. Not a red button.
All right, I was probably close to doing that. All right. Okay, so now we're back to the rule. And I make you guys all go away so I can see it better. And so we go down to section 8. So right now, section 8 is only about government to government. So we're only talking about tribes here, but we already have it, right? So section 8 addresses a way a local government and tribe can work out a better approach to protection of tribal sites. And this isn't just limited, this one isn't limited to archaeology, it's archaeology and landscape areas. And that is done through a government to government memorandum of understanding, and then some other things so we all know what's going on. And then that new program goes into replaces the baseline protections.
So would your new language be a bullet I can't see how far down it goes. Remember, G under this 8, or where would this new
No,
bullet?
this would then be, like, if I did the other one, so this would then be
It would just
A,
say in addition
and
to.
then all of these, then everything would, like, basically this, can I just do that here, would become a little a, right? And then all these other things would become like 1, 2, 3, or whatever, and then we would just follow the outline as needed. And then we'd have a little b, and that would capture what we were just talking about for protection of archaeological sites of non-Indigenous origin.
All be under the header of government to government
Whatever we
consultation.
call I don't have a name for it yet.
I think the point that I am trying to make, and that, I won't speak further, but the point that I'm trying to make is that this shouldn't talk about the origin of the sites at all. It doesn't need to reference who made the site. It's about sites generally, because it's for the tribes to decide if they're interested in it or not. And by saying of non-Indigenous origin, can give the impression immediately that tribes don't have an interest or connection to it, even if it's connected to Chinese heritage or to settler heritage or to something. So my concern is the calling out of non-tribal origin as a misnomer.
Great. So Amanda, just caution on time. I would say let's not solve that today. That's a good problem to have. Cassie, thank you, and Carrie and Sarah for clarification. Brees has his hand up, and John's been super patient. John, do you want to go first, and then Brees? Okay, now you have to find the button. There you go.
Yeah, thank you. Now in my bar at the bottom popped up and wasn't letting me get to the button, but I think a lot of this has already been said, but I just want to point out, so like a couple of things. In statute, an archaeological site is 75 years old. It doesn't necessarily, it just says that it needs to be part of a culture in Oregon. Tribes are the indigenous folks here. So even if there is a Chinese site or a settler's cabin or associated archaeological site with that, those are on places where tribal people have been. And I think that as some of the comments in the chat have been going, is like, and they're still here. So, they still have interest in these places. But I do agree that, like, reaching out to groups about, like if it's a Chinese site, that would be important to reach out, to those people. But I also wanted to say that archaeological sites aren't always that cookie cutter, where this is just non-tribal and this one is just tribal. They can be mixed together, and that happens very often, and that can kind of complicate things. So I just feel like that it's just almost better to just kind of treat these as they are in statute, as archaeological sites. I think that tribes would always need to be contacted regardless of the type. So I just wanted to say that, and I'm kind of backtracking, and then I'm going to shut up here for a second. But in that part where it says a local government can request a survey or something like that, because the statute says that thou shalt not excavate, injure, alter, damage, or destroy an archaeological site. I just want to know, like, what happens if the local government's like, no, you're good, we don't have a problem, go ahead and go. And then if there was something, so I just want local governments to, I mean, we have to deal with that at SHPO as well. And I know that people like to, come back at us every now and then if we recommend a survey, and then they're like, gosh, SHPO made us do a survey and we didn't find anything. Well, the reason why we do that is that's kind of trying to help protect you a little bit with the statute, as even though it's not worded in the statute, that's like a good faith effort. It's like you tried, and then if later on an archaeological site is damaged from a project, we look at that as well, they these happen because these things are a lot of times underground and can't be seen, so we're never going to fully know everything. But the effort to try is much more better than not. So that's jumbled, but that's, I'll stop and let Breeze go. He can probably say something a lot cleaner than me. So
Thanks, John. Please.
Actually, I was going to thank you, John. You just saved me from saying a couple of things. I think part of where we're getting bottlenecked is we have government to government, as that title in that section 8 is called out there. And that means something very specific for tribes as a government in that relationship. A friends of the historic place of X is something different and not in the same tier, if you will. And I think maybe part of this, and we may not get the solve at this moment, but it may be the moment to say, oh, we're crossing threads here, and maybe what we need to consider is what we are trying to make sure gets captured is actually maybe a different section or somehow called out different from this government to government process. Your language down below calls out MOAs and memorandums. Those are very particular documents with obligations, etc. So I just put that in there for consideration that that may be where we're finding ourselves bottlenecked, and teasing that a bit of a mitosis between G to G and other process may be worth considering. They would then be running concurrent.
Can I ask you a question? And all tribal representatives here today is it seems silly, but I just want to state and check that government to government can also be local government. Yeah, so cities and counties. Thank you. Yeah.
For Grand Ron, yes.
Thank you. I know there's this. Thank you, Regent. I'm sorry. I know that there's a consultation task force going on that's sort of clarifying maybe some of the terms, but right now, when we read government to government, be any level of government.
So I'm wondering, I think that the new language that we've been talking about could be made not say non-Indigenous if a government to government agreement with tribes was not required for a local government to adopt it. So I think, Breeze, you're bringing up a good point. And I don't know if that's too big a question to ask right now. So we could also leave it as it is, because essentially all the notifications to tribes would stay in place. If a city wanted to require people to survey before digging in a known Chinatown, let's say. But if we wanted to not say non-Indigenous and just any of these of a local requirement for pre-development surveys, if the tribes are okay with a local government adopting that without a specific agreement with the tribe, then I think we could make this subsection generic.
Sorry, I think so. I think Nick and Sarah in the chat have really good points, and Nick calling out basically what you're saying of maintain the notification element, but Sarah's part, Sarah Palmer's call out, it's really important to not inadvertently force a separation based on perception without it being informed and defined by those communities. So if we step away from trying to assign an identity, and step into the process of notification and the process of these are the steps to make sure that the archaeological and the cultural resource needs have been achieved. And we can do that not necessarily by hanging labels on. In fact, the work will help identify and inform the identification.
Thank you. Amanda, is that good for now? Because I know you have several others.
Yeah, so basically this will be a local government may also, and then go into the language without having it a title that says non-Indigenous. Yeah, I think we can work with that. And just sounds like you, at least the people in the room are okay with a local government adopting that kind of program without first consulting with the tribe.
Notification processes. So because it doesn't include ground disturbance. So, you just raised a big question, which is that tribes wouldn't automatically be notified of this unless they worked out an MOU with the jurisdiction. Carrie has her hand up.
Can I just a clarification
Yeah.
that the notification requirements in 5 archaeological sites would still lie, right? This, and in addition, right, whatever they can do here, this will not affect the notification to tribe requirements. I'm not trying to say that at all, but what I'm making sure is that if this rule allows room for local governments to require a pre-development survey, are tribes okay with a local government adopting that without first consulting with a tribe? And again, it won't change any of the notice requirements in section 5 of this rule.
For actual ground disturbing activity. This would just be the designation of an area that would require notice for ground disturbing activity, if I'm
It's
understanding.
more than that. But it is more than that. But so, yeah.
Let's hear from Perry. Yeah, thanks.
Well, I think it's still, I'm just kind of trying to work through this because you're like, would the tribes be okay with it? I think we, Umatilla, would prefer that someone says, hey, please go out there and survey. This is a high probability area versus the county or local government not saying that at all, and development moving forward. But that said, I would like to in that government to government relationship, just have that notice. And that goes out to that applicant or whoever that the tribes get notified that here's the next steps in the process to go help to see if to identify if resources are going to be impacted, right? So that we know they're out there, we know they're going to do the work. Hey, they're looking to see if there's resources that are going to be impacted. So my concern with all this new language was like, hey, if there's a high likelihood, I want that to apply to tribal sites as well, and not just what we're saying was non-Indigenous. And I think we resolved that with this sort of language discussion that we're having. But I wanted to make sure that these other high probability areas get the opportunity for someone to say, hey, we know that that's, a really important place, and that there's some resources that can speak up and then, say that let's go get a survey done. But I do want that conversation. I don't know how that can happen, but like right now, if we're getting notices, couldn't we just add this as another notice that goes out to the tribal government of here's the action that's being required or recommended?
Nick gave that a thumbs up. Yeah, Nick's affirming, head nodding from his perspective. So, okay, so let's work on that, Amanda, with that understanding that this also category would require notice at tribes, and in LCIS's year, that would be one of the questions that LCIS staff would work with on tribes and understanding which area, for which cities and counties in the state they would like notice. And then Brees is concurring, Sarah's concurring, Cassie's.
We'll have to have some conversations outside of this so I understand at which step in the process we're talking about.
Right.
But
right.
Yeah.
Right, good. And Sarah, great. So put in the chat, and rural counties tribal staff are going to be among your more experienced technical practitioners. I'd encourage you to see us as a resource, and notification as an opportunity for improved land management. Thanks, Sarah.
I think I'll say that if a local government wanted to do this just for one area, and the Chinatown is a really good example. The reason they're doing it is because they are maybe Chinese Americans in Portland have requested this to happen. So that's the focus of the local government adopting the code. And there's nothing here that's saying that they would have to apply such a program jurisdiction wide. A local government would be just deciding to say, hey, this is an area we're going to address right now. And I hear what you're saying, that even though the intention is about might be there from the old Chinatown, that doesn't mean there's not indigenous artifacts there as well. But what I'm saying here, the example that we're talking about, or what we're trying to make room for, is not assuming that a local jurisdiction is going to require a survey or identify high probability areas throughout their jurisdiction. They might just pick them off one by one on as they see, what their very careful with my words here, what's on their policy agenda, right, for, that year.
I think that's understood. I think that's understood. Good. You guys, thanks for the discussion. I'm going to help Amanda move on to the next item on her list on the agenda. And I wish I could be helping you share. And if you save that on my drive, I could put it in the chat.
It is there. It's under the folder for this RAC 5 meeting.
Okay, I'll go find it and put it in the list of topics in the chat. Yeah.
No, I didn't save I didn't create a PDF. So we're working from a Word file, but I will save it. So if you end up sharing it, you'll have the same thing.
No problem.
Okay. So we're gonna have to do this by importance. I would like to, here's a big one. All right. So two I'd like to cover. One are considering dropping the definition of archaeological sites of significance, or sites of archaeological significance, I think is how it's worded. That definition we pulled from statute. And the other is touching on making some changes to subsection 2. So first, let's do this one, which is considering dropping the definition of archaeological sites of archaeological significance. So I'm going to now go to the rule again. And up to the top, because it's definition. And the reason here, as I'm doing this, I'll explain, is our rule, and not only just this rule, but SHPO rules really don't distinguish. Like there's not any real difference between whether a site is would meet the definition for site of archaeological significance. So it's here we're talking about, or no. And this has brought up a lot of consternation, because the definition of a site of archaeological significance says that it's eligible for citing on the National Register, or if a tribe submits in writing to SHPO that it is a significant site. And that the public process for certainly that latter part, but even listing something on a site of, well, we're not even talking about whether they're listing, whether they're eligible for a site for listing, that doesn't have the same kind of public process requirements that we rely on in our land use program. So by taking out this definition, it doesn't change anything about how our rule works, because notice requirements apply to any archaeological site. It doesn't have to be a significant site. And it removes the consternation about process that makes it more difficult to bring into a land use rule.
Any concerns? Reese is saying he agrees with removal. The chat.
Yeah, and I've had this conversation with Amanda. I guess I should have raised my hand. Sorry, I'm just jumping in.
Please.
But we don't have a rule for our statute yet, and it does not say that it's a violation to excavate, injure, alter, or destroy a site of archaeological significance only. Is any archaeological site, whether it's listed, eligible, or frankly not eligible for the National Register, the way it's worded in statute. So every archaeological site needs to be kind of considered in that light when we're applying that particular part of the statute. So to me, it doesn't matter if it says site of archaeological significance or just archaeological site. And for that matter, the definition of an archaeological site is that it's comprised of archaeological objects, and it just uses the plural, so that can mean two. But the permit statute is also for an archaeological object, so we have to consider all of these things. And because of those reasons, I don't have a problem with having it removed. I don't have a problem that it's in there either, but removing it may make it a little more clear.
Thank you. And I'll say that I think, at least I, and maybe more of us, glommed onto this because this definition, because it has significance in it. And the distinction between a resource category and a significant resource within that category is kind of part of how Goal 5 works. But in this individual rule, I don't know if we have to come right out and say that all archaeological sites are significant, or we just are more clear about how that step of determining significance is over in the standard process is overwritten by this rule. So I will have to work on that part too. But essentially, since all archaeological sites are being treated the same, we either say they're all significant, or we'll say significance doesn't matter with the application of this rule.
There's several thumbs up with that in the chat. Amanda, I'm not sure if you're able to see, but LCIS, Spreece, and Curry.
Cool. Well, thank you very much for support for that. Let's see if I go back here, and I'm going to stop sharing.
Your list in the, and then Sarah, do you want to put voice on yours? I can read it too. I'm not sure Amanda can see. Sarah wrote that I strongly support having one definition of archaeological site in a state instead of multiple, where she's an invitation to chaos from her experience in other states. And then Cassie also wrote that significance should not matter as far as this rule go, just refer to state law. So thanks. Which is
thank you. So can we move on to this, the changes to section 2?
Yes, please.
All right, and I can bring up the rule if we need to, but so we heard several people who in the hearing at LCDC, and then written comments, and then as people were introducing themselves today, a concern about right now the rule basically defers to a rule that we don't have yet for dealing with cultural areas in relation to citing solar on farmland. At least in that, this rule isn't about citing solar on farmland everywhere. It's about identifying least conflict sites for citing solar, but the
in Eastern Oregon.
In Eastern Oregon. And the direction that the RAC for that group has been going is that they're not going to be able to identify both historic, archaeological, and cultural resources ahead of time. So I'll use the word survey or research or whatever it is will be required of an applicant, even if they're applying to cite a solar facility in whatever might get mapped as a least conflict area. A little bit more for those who aren't aware that the rule for the solar siting sets up a process for counties to follow if they want to adopt these areas, or if they want to identify and adopt areas of least conflict solar siting, but the rule does not require a county to do so. So because this rule isn't written yet, what we're thinking is the best thing to do is just take it out of our rule right now. So in section 2, which is the cross-reference to other Goal 5 rules, we'll just take it out of our rule, because if it's adopted, if our rule's adopted in December, it's before the solar siting in Eastern Oregon rule will be adopted. And then we'll let the adoption of the solar siting rule possibly put something back in to this rule. But at that point, we'll know what they're requiring. And so we'll better know what the crosswalk is. The intention all along is that we have been assuming that what they come up with in the solar siting rule is going to be much more comprehensive and afford more protections than this rule does. But since we don't absolutely know that yet, we will leave it for that rulemaking to come back in and stick something in our rule if needed. Reese.
So to confirm that I heard this right, the other RAC is proposing, and I'm assuming it's got traction, that regardless of the location of a solar farm, that it will have prior archaeological survey and the results to be addressed.
Yeah, and then so mitigation would be required for impacts to historic, archaeological, and cultural resources.
Does that rulemaking keep it that the are they proposing, if you will, a menu of mitigations, or will mitigation be a site by site?
I think it's too early, certainly for me to say. That would be John Jennings and Adam Tate are the people who are working on that rule.
All right, thank you.
Can I just chime in though? So, I mean, they're trying to give, oh, sorry, my camera's off. They're trying to give some like general ideas, even in talking about compensatory mitigation. If you can't do things right on or take those acres off, but it's still all being developed and I need to dive in more to it. But there's like a broad sweep of ideas that they're looking at. Sorry to just chime in.
No, Carrie, thank you so much. And Carrie, so this is, I feel a sort of a settler layer identity here, very present to say that tribes that we think have an interest in Eastern Oregon have been sort of closely invited and staff to staff coordinated with on the Eastern Oregon rulemaking. So if it's, you might be thinking like, what rulemaking? That's not to say that Confederate Tribes of Grand don't have a statewide and beyond interest. So when we do have, I was just going to put in the chat, and I will do that. When we have a draft rule on this, it is set to publish in the Secretary of State notice November 1st. We'll make sure to initiate invitation for formal consultation with all federally recognized tribes, and that consultation period is 6 weeks through December 14th. So again, we should see this nexus with this rule in that rule. But folks at commission, as Amanda said, had a concern with reference to a rule that's not yet written. So we should button that up here. So that their rule, the intent is that their rule actually reflects this rule because it comes later. And since we don't have Adam and John here, I would say we have enough to deal with in this rulemaking. So Ed, your comment is good, but I'll put it over to an email to Adam and John and Gordon, who are working on the Eastern Oregon rule.
I just real quick, I had my hand up, but I was just gonna, yeah, that's fine. I think all the folks from tribes here and others are part of the culture cluster, and I think this was brought up at the last culture cluster meeting because it's part of DOE's FSEC process. So I think that if folks want to be part of that RAC, I know that I requested to be. I made sure that I voiced that at the culture cluster meeting, and then followed up with an email. So I would encourage others to do so if they're interested in that.
John, I'll put that gentleman's contact either in the chat if I can do so during this meeting without being super distracted, But that is actually, respectfully, I just want to say that that is a next rulemaking by Department of Energy. And the one that's Eastern Oregon solar siting in Oregon came from a legislative mandate, and it is due like by June, but we're wrapping it up before the legislative session. So it's currently, there's actually a second DLCD rulemaking right now on that kind of related Goal 5 effort, but just for Eastern Oregon. So 3. Thank you.
Okay.
And
I'll
John,
need another email.
exactly, John. I will definitely link you to that website right now and do an e-introduction of you to John and Adam to get you, just you could be on the list of interested parties as well for that if you wish. And anyone else, if you just want to message me directly or in the chat, to everyone, that's fine. We'll get you added to that distribution list. Thank you. Sorry, Amanda, where were you?
Right. I'm just kind of giving people orientation of where we're talking about in the rule here. So, so here's section 2 of the rule. And section 2 of the rule is a relationship of cultural area protection to the standard Goal 5 process and other rules in this division, Division 23. So what we just talked about was striking what is currently F, which is talking about the solar siting rule, which is in Eastern Oregon, which has not been adopted yet. And then the next thing I wanted to talk about was possibility of adding a new section that describes the intersection between this rule and our Goal 5 rule for aggregate, which is the 023-0180 rule. And just a little bit of an explanation there for people who don't have a lot to do with aggregate. But what that rule does, it's in Goal 5, aggregate's a natural resource, but it kind of works in reverse. It's like it says, it reverse to how we normally think of resources like riparian areas, wetlands, cultural areas. It's like, let's keep development away and protect these areas as they are. For aggregate, aggregate site, a significant aggregate site is identified. And then if it meets the definition of significant, which are very specifically written out in the rule, then the local government goes through a process to determine whether mining will be allowed at the site. And it's going to be very specific about like where things can be located, how many trucks can come and go, what their operation hours are, where berms have to be to make sure it doesn't make too much noise for noise sensitive uses. It also has to address conflicts with existing significant Goal 5 sites on an inventory. So like we've had a situation where a wetland is in the middle of a proposed aggregate site. The process for approving mining on that site has to address that wetland. It may not end up protecting the wetland. It may end up protecting the wetland. So we have, and when these aggregate sites are identified and the applicant goes through the process to determine whether mining is allowed on the site, that is all done because of the long range kind of economic planning that is done with aggregate sites and the amount of it, costs a lot of money to develop the site and all that. So they want certainty for their sites. And but the site can be large enough to provide aggregate for 50 years or more. And so the question for this rule is what should, could, or would happen if a new, if a significant, if a landscape area of cultural significance was identified inside an already locally approved, adopted mining boundary for which mining is allowed. And part of this, so the conversations I've had, and Cassie was in one meeting that I've had with a couple people who work in the material source perspective from our Department of Transportation, because having aggregate sites to have material to maintain our highways and roads is important. And so the question has come up is, should this rule say something specific about how it applies to an already identified aggregate site on which mining has been approved by the local government? Maybe I'll stop there and see what folks might have to say.
Cassie has a hand up.
Yeah, I'm gonna just jump in here, and I want to be really clear that regardless of what has previously been approved, state law continues to exist, and mines, quarries, these aggregate sites, they still have to follow state law as far as archaeological resources go.
Yeah.
And that's something that always needs to be clear. And folks need to bear in mind. So if they're going to be changing their expansion areas, or if they're going to be doing some new disturbance, that they still have to do that survey and assessment and responsibility for archaeological resources. So as far as landscape areas, my recollection is that there is no requirement for survey of landscape areas in the document, right? So I think my read of this is that it's kind of a moot point.
Well, going back to the conversation earlier about the ability of whether a county decides to do a area-wide survey, or inventory, let's use that word, because that's what they would be doing for under Goal 5, or if somebody could come and make an application for a county to recognize a landscape feature as culturally significant and then continue through the Goal 5 process to put protections on it. Maybe whatever we resolve with our earlier discussion today about how private property is handled, ODOT's material source sites are not private property. So maybe it wouldn't, but we certainly have plenty of aggregate sites that are privately owned and operated. So the discussion earlier about private property will have some bearing maybe on what's the best approach to this, but as far as aggregate sites generally, if there's a boundary that includes let's say a 50-year supply of aggregate, and if someone were to come to a county and say, we would like this landscape area of significance to be recognized that exists within that aggregate mine boundary, I'm thinking that this rule, it's not a lot of area out there, but I know it's important area, that this rule might say that that it can't put new limits on mining that are not already in the local comprehensive plan for that aggregate site. And I guess I didn't say.
That's a different thing than saying it shouldn't be surveyed or documented, though, right? Just because you can't change an existing approval doesn't mean that you shouldn't also still designate, hey, there is a resource here that for future approvals or permits or processes should be addressed and considered in future. So I just want to provide that clarification. I see Sarah's got her hand up as well.
So let me explain that. So when mining is allowed on a site, it's either allowed generally it's an overlay zone. Sometimes it's actually the base zone is changed from whatever it was before to a mining zone, but generally it's an overlay zone. And that overlay zone pretty much lives with the site until the site is exhausted and reclaimed, because we have state rules about how the site is reclaimed. So it wouldn't, essentially, as you can imagine, mining for aggregate, if there was a landscape feature of significance, whether it be of vegetation, whether it be a shape of a landform, once the aggregate has as the aggregate is extracted, that feature will no longer be there, I would think. I can't think of an example where it would stay.
I am gonna, before I hand it over to Sarah, I can think of some examples. It would not be appropriate for me to cite those in the specific instance, but I will reiterate that cultural landscape features aren't always only physical features. They are sometimes intangible resources or intangible feelings associated with a place or associated practice. It doesn't necessarily have to do with the physical ground. So I'm over to Sarah.
All right, thanks. Sarah?
Well, I'd like to agree with a lot of what Cassie is saying, and I'm going to give you an example in sort of vague terms of a situation where we might have a conflict with mining that I think all of us would agree we would want there to be some opportunity for intervention. I've dealt with situations where we had, not in Oregon, but up in Washington, where we had people who had licenses or permits to do mining, and they were operating in talus fields. And that was an environment where we knew that there were burials. And so we do in some places in the Northwest have places where these different kinds of mining opportunities really do intersect with serious cultural resources concerns, and where I think that most citizens of the state of Oregon would agree that it's inappropriate to mine burials. But you can absolutely get into situations where that is happening. And I think that that is the kind of situation where you want to have some capacity for review or conversation. You don't want to just say, well, it's permitted, we're done. Even if the permit was issued some time ago. Now, there are also a variety of mining protections under state and federal laws, because of course mining law is very old law and a lot of it hasn't been updated. And that's where I would frankly, this is a bit of a specialist lawyering job where I have just enough experience to say you really need to talk to a lawyer who is very up on this. And I don't know if there's somebody like that at DOJ, but I spent quite a bit of time in Washington with somebody at their DOJ who was their mining guy, because it is really complex where you have these kinds of concerns intersecting with mining law. So that's what I have to share.
Yeah, thank you, Sarah. I will distinguish that we're not talking about all kinds of mines, like mineral mines. We're only talking about aggregate. And I'll say that we continue to be lucky that our attorney is also the attorney for state parks, including SHPO. So we have somebody who definitely can work between those two different sets of rules. But I believe our rules for aggregate stand alone, because the other mineral rights that I think you're speaking of are not there. That's not aggregate. Aggregate is only rock that's used, for making concrete and asphalt, essentially. And then I'll also just touch on just what you mentioned about burials or any other archaeological category. As Cassie just mentioned, all those laws would, of course, still apply. Our rule can't change any of that.
Carrie has a comment in the chat. Carrie, do you want to come on and say that? And then I think Keenan has his hand up too.
Sure. I think I'm just sort of echoing what Sarah said, and just expanding that, maybe we're not talking about taking everything out of aggregate, but if we're going to write a rule that they're exempt, then we lose that opportunity to work with, say, that landowner to be like, hey, can you do X on the east side because this area is important, and continue to mine over here, or whatever the discussion might be. If we write it, then we don't have that opportunity where I do think there's some good people out there and say, oh, if that's really important to you and I can still do my business, that maybe we can come to a compromise. And so I would hate to see that we don't have the opportunity. And I guess just a reminder that, we're trying to work through this really complicated thing about these cultural areas and these sites. And many of these aren't on inventories, but that's not what this didn't say almost 30 years ago, right? We were supposed to do these inventories a little bit more elaborate than what was done. And so, yes, we're dealing with a situation where, a lot of these important places aren't on inventories, but Goal 5 still protects these areas. And so how do we mesh them? Because the aggregate got inventoried, these didn't get inventoried. So, how do we balance that? There's not really a great answer, but I would still want the opportunity for the discussion. I'll stop there. Thanks.
No, thanks for that. And so, I think it's clear that we're talking about only existing sites. Every year we see, I don't know, one or two more sites come in for identifying as Goal 5 significant aggregate sites, but we're only talking about ones that already have made it through that process. And the way some counties allow mining is it's not necessarily, the mining isn't allowed kind of automatically, like the limits and requirements for mitigating impacts of the mining to the surrounding land areas. That's all written into we'll call it a conditional use, but it's actually in the comprehensive plan. It's adopted as a comprehensive plan element. But the applicant or the operator, the aggregate producer will identify subparts of that area and get have to get some of their mining plan kind of approved kind of piece by piece. Not all counties do it that way, but some do. And that would be a nexus for possibly requiring a conversation with the tribe to work on a compromise, or maybe this rule, I'm not sure how it would happen, or maybe it would happen outside the rule to get counties to send information to all of their aggregate producers with information with tribal contacts and encouraging them to have conversations about working out compromise. So that's something that maybe we could do within the rule if we do say something specific about aggregate sites. And it could be something that we could do outside the rule with our outreach efforts that we're not going to get a chance we won't have time to talk about today. Talk about soon.
Great. Amanda, is that my segue? Is that my cue?
We got Keenan up, and then I think.
Sorry. Yep. Cue. Keenan.
Thank you. Yeah, I think Carrie raises some really good points here because I mean this is I think one of the trickiest aspects of the rule. I do a lot of work with the aggregate mining industry, so I like to think I understand the parameters decently well. I'm not necessarily sure, Amanda, if you're talking about including a carve out here for future expansions of already designated Goal 5 aggregate resource sites, or if we're talking about existing designated sites. Like you noted, there is some interplay between not only the designation piece, but also those secondary approvals that some jurisdictions require. But if we're talking about a site that's been designated and is being actively mined, mining doesn't happen all at once, right? They move in phases throughout that designated area. So I am concerned about coming in after the fact and implementing another review piece onto a designated site, notwithstanding that I think it is certainly important. I just think that raises some regulatory takings issues, a certainty question. I just want to be careful we're not treading across that line here.
Right. Yeah, thanks. And I have only been talking about existing approved. So both, there has to be a significant site and mining has been approved by the local jurisdiction, because we have significant sites where mining was not approved.
Mm-hmm.
So, but when you ask about new sites, and I think it's probably too late in the game here to use this rule to add a step to the rule that speaks of how mining is, how mining sites are identified and how mining is allowed. Because as you all can imagine, it's very, big issue. People very, emotionally and economically invested in it, and we have not really done a good job reaching out to the mining community or the aggregate community, I'll say, in this rule. So it might be, I think it would be very hard to add process steps that are not already in the Goal 5 rule for aggregate sites. However, when a site, when in the future, when there is a landscape area of cultural significance on an inventory and a new application for a new mining site comes, or aggregate mining site comes in, then any significant landscape area would need to be addressed in the whole application of the existing aggregate rule.
Yeah, exactly. I think one other thing I'll add here too, I mean, this doesn't solve the landscape issue for existing designated sites, but if there was an inadvertent discovery at an existing site, all of those protections will still apply. So I don't necessarily think we're talking about mining and burial areas. I mean, I don't think anyone would think that's appropriate. And I think there are existing protections for that as well. But I recognize that doesn't solve the landscape issue.
Yeah, I think there's maybe interesting conversations to have about restoration plans, to Cassie's point about just being in an area, even if it's altered, if that is an important experience to preserve, then maybe that is something that could happen in the conversation around reclamation of these mining sites, of these aggregate sites. And so I know we need to move on. I'm just going to flag the things that we didn't talk about. So a couple just edits to the rule that we didn't get to talk about today. Some typos, one a little bit larger than a typo, like a fragment section that ended up being in there. It's confusing. I'll have to fix. And what else? We got to definitions. Oh, clarifying that culturally identified groups, as they're treated in this rule, include federally recognized tribes in neighboring states.
Anywhere else, actually, anywhere outside Oregon. It could be Montana.
Okay.
Yeah.
And that's it, I think.
Good job, Amanda. Okay, you guys. So you always give us our work cut out for us. So thank you for the good discussion today and raises some very, very serious issues. As we said at the beginning, we would not have been able to do this without you. So I'm just going to reiterate in all caps, please send all comments from tribes, from local governments, from community to Casaria Taylor by October 16th at 11:55 p.m. You're welcome to copy me or Amanda or the director. Casaria does a great job of quarterbacking several rulemakings over the years, including this one, and lets us know when comments are received. But she is our rule coordinator on this, so that's the destination. If Amanda and I receive anything at this point, or Elliot, we shoot it right over to Casaria for processing. So we welcome comments on the record. It really helps us remember, what you're saying, focus on what you're saying, diagramming what you're saying. And as we've discussed today, we'll be looking into, the issues that Dave brought up at the beginning around sections 4 and 6. Taking, discussing that with our director and making a staff recommendation to the commission for their packet, which will become public on November 21st. So that packet comes early because the December meeting is early. So within about a month, we'll be responding to kind of really focusing on all the tribal and public comment, making a staff recommendation to commission. Any comments we'll receive, we'll be putting those out in an appendix for the commission to review. And then working on implementation. So Kimberly mentioned the kind of the technical advisory committee that will be imperative to help us move forward. We'll do a full call for that among RAC members. So you guys have kind of an automatic seat, if you will, as we look forward to cohering that group and adding anyone else, but giving you an opportunity to roll off and take a break from meeting with us for the next year. But we will rely on the Legislative Commission on Indian Services to continue to consult with tribes on the areas in which they would like to receive notice if this rule goes through. So that was a very important part of 2025. And please be in touch with any other questions or comments at any time. Amanda, did I forget anything? Sarah, did I forget anything?
No, I think you covered it.
So
Who are you out? That was great. Good job. 3 hours. Everyone, thank you. Is Commissioner Thompson still with us to give us any final words?
I'm here. I saw you rubbing your forehead. I thought you were stimulating your brain instead of tearing your hair out, right?
I'm trying to. That's what the hairband is for.
Well, and here we are well engaged in this. I'm really contemplating how we continue the conversation so that we balance and harmonize and that do no harm as we include each other's cultural heritages and current needs and future development into consideration. I'm so grateful to be part of this group. Thank you, everyone, for your expertise, your intelligence, your wisdom, and your heart.
Thank you, ma'am. We'll see you on email and hopefully soon. Thank you, everybody.